Clarence Rowan. Clarence Wade Rowan. D'Anthony Smith. Today is Tuesday, right? Matthew Kearns. Thank you, Ms. Bush. Heaven Weed. Samuel Turner. Thank you, Ms. Murray Leader. Kayla Curtis. Kayla Curtis. J. Byron Riddle. David McLaren. Thank you, Mr. Woodwike. Marcus Gardner. Landon Musgrave. Mr. Sanders will be late this morning, and his client, Mr. Musgrave, is appearing via Zoom due to potential COVID symptoms. Amethyst Wesley. Amethyst Loney's Wesley. Ryan Hare. Ryan Lee Hare. Joshua Hand. Joshua Ray Hand. Bobby Joe Richards. Justin Wayne Williams. Amy Harmon. Misty Rice. William Robertson. Have a note that he's in Senecor in Waco, Mr. Stevens. Is that right? All right, we'll call his case in a minute. Tracy Smithhart. Ronald Toll. Leonard Williams. Leonard Marshall Williams. Thanks, sir. Antonio Lano. Elaine Jeffrey. Thank you, Mr. White. Mitchell Ragland. Thanks, sir. Keith Thomas. Keith LaTroy Thomas. Oh, I'm sorry, that's 11 a.m. We should be good on that. Is there anyone who's present in the courtroom whose name I have not called? All right, and counsel, if you're ready, if you'll form a line over here to the left, and I'll get you called. Cheat sheet, did you give it to me already? Matthew Kearns. Good morning. This is cause number CR 2199, State versus Matthew John Kearns. We're set for pre-trial today. Mr. Kearns, do you understand that Ms. Bush, another licensed attorney here in the state of Texas, is filling in for your attorney, Mr. Heathide? Okay. And Mr. Kearns is set for pre-trial today. Do you know if Mr. Kearns has any contested pre-trial motions?
I do not know that specifically. I do know that I was told that he had been talking with Ms. Curry and that this would be the next step.
Do you know if there's any discovery issues or anything that would have the court not move past pre-trial?
I assume there's not, or they would tell me, but if you would like to do a step back.
I'm just going to check to see if he filed any pre-trial motions. State, Ms. Heisel, do you know, are there any pretrial discovery issues on Mr. Kearns that would have us not set this for docket call?
There's not that I'm aware of. I know that this is reignited under a different number. It actually died under another number first, so I believe that all the discovery has been fulfilled. I'm not aware of it. I can't say with friends. I have known from last week that since the attorney was notified that this is already.
And they were made ready last week, or the notice was sent out that they're ready last week?
The notice was sent out today already last week.
So he hasn't viewed the discovery on those discs.
From what I've seen in the system, it doesn't look like that.
Do you know Mr. Hyde's calendar at all? All right, court's going to reset Mr. Kearns for pretrial on October 26th at 9 a.m. We'll give him time, and will you relay that message to Mr. Hyde that he needs to pick up discovery in the DA's office?
I will certainly do that.
Did you do a notice of setting? If you want to, you can give that to Mr. Bush and she can go fill that out with him. It'll be October 26th at 9 a.m. Mr. Kearns, once you sign this notice and get the yellow copy, then you'll be free to go. And then the white one stays here. Okay. Your name, sir? Ms. Weed? Let her get up here. Let me call this on the docket so we make record. This is CR 21-197, State versus Heaven, Leanne Weed, and we are set for docket call. Go ahead, Mr. King.
Hi, Your Honor, we're still in the middle of negotiating this question of setting. We are.
You available on October 26th?
Yes, Judge.
Okay, we'll set Miss Weed then for docket call on October 26th at 9 a.m. Do you have your notice of setting, Mr. King? You got that? Okay, good.
You need to close out of that.
No, you can fill it out and give that date, have her sign it. She'll get the yellow copy and the white one will stay here with me.
Thank you, Your Honor.
Ms. Weed, once you sign and get the yellow copy, you're free to go.
Will you excuse me, Your Honor?
Yes, thank you, Mr. King. I'm assuming by the lack of counsel standing here, we have no one else that's ready to go.
Great.
Okay. Justin Wayne Williams, CR 2276. Mr. Williams is set on a motion to revoke. What I'll do is I'll set Mr. Williams for a contested hearing on October 28th. So that'll give you a pass, but if we're not resolved by the 28th, then we'll go forward on state's motion. October 28th at 9 a.m. Mr. Williams, once you fill out your notice of setting and get the yellow copy, then you're free to go. sorry. So. Give a perspective. I like it. I'm surprised by it, but I like it. Mr. Pappas, you ready? Mr. McLaren? This is CR 2263. I showed Mr. McLaren set for a plea today. We plead in this case today.
Honor, he's rejected the state's plea offer. I have advised Mr. McLaren that he's ready to respond if the court seeks to acquire him. He rejects the state's offer.
Well, just fill me in here, because I thought when we set it for a plea, that meant that he knew what the plea bargain was. He had accepted it. We were doing paperwork, coming back, going to enter the plea.
He's changed jobs and even a felony misdemeanor, felony deferred will cost him the job. It's a trial case for the side. It's a motorcycle.
What's the state's offer that's being rejected?
Or deferred 2,500 80 hours.
Is that the best offer the state's going to make in this case?
Yes, sir.
All right, so Mr. McLaren, you understand that if you reject the state's offer today and make a counter offer and they reject that, and we move past this date and I set you for jury trial, you're going to have a trial. I'm not going to allow you to come in here the Friday before and go, you know what, I really don't want to place my case in the hands of a jury to decide, one, if I'm guilty, two, if I'm going to go to prison or not. May not decide you want me to do that either. The Friday before jury selection, anytime after today, before that jury trial, I'm not going to let you enter a plea. The only plea that you could enter would be plead open, plead guilty to the court, and the court would assess your punishment. That's the only thing that I would allow. So you understand that? And you understand that jury could come back, they could find you not guilty and you'd be acquitted and walk away. But at the same time, you could be found guilty and you could get the same offer, you could get a worse offer, or you could get a better offer or result rather on punishment. Do you understand that? No, I understand. I understand, but you understand that while it might be scary today, it may be even more scarier. Test. That's got it. It may get.
That speaker up there has to be. You see that speaker on the right side? It's not the speaker you got in your hand, those are my speakers.
Sorry about that, Mr. McLaren. So you understand that while, you may be under pressure today and worried about that, that's not going to subside right before trial. Okay, I just want to make sure that we're clear, because I don't want you to come in and say, I didn't know what I was facing. I didn't know that I could be found guilty. I didn't know that I could receive a punishment from a jury or from a judge up to 10 years in prison. I don't want you to say that. You understand. And so you've spoken about this with Mr. Pappas, and I'm sure he's gone over this in great detail. It's your decision today, but I want to make sure that you're making this decision with all the information available to you. And you feel like you've had enough time to consider that, and you're making this decision today because that's the decision that you want to do. You want me to recall your case in a few minutes? And sure, I'll be happy to do that. I'll recall you in a few minutes, and you and Mr. Pappas talk about it. And Mr. Pappas, what can I just ask? What is the job that Mr. McLaren has that's could be?
No, he was a working driver.
Okay, thank you, sir.
Yeah, we left here. But
I understand. Mr. Wheeler. This is cause number CR 1973. This is a sanctions status hearing. Mr. Wheeler, I see here that you did everything that I ordered you to do at the last hearing. I'm going to order you to do that same thing. We're going to try to keep you on track doing that so that you can successfully complete your community supervision. Are you having any problems getting that done? Okay. All right, so I'm just gonna order you to do the same thing, 30 hours of community service. We'll tie it to a day in jail for every 10 hours, same as we've been doing, okay? I've got a note from the probation department that they want me to make sure that you understand that unless you get your fees paid as well, they're gonna be forced to file a warrant where I file a motion due to your expiration date coming up. You're gonna expire in about less than a month and a half on November 13th. So if you don't get these things done before your expiration date, in order to preserve those violations, they're gonna file a motion to revoke. And that's gonna result in a warrant. You're gonna have to be arrested. Right now, we're on a sanctions court status. That's where I can just tell you, hey, come in. We talk about what you need to do. You get it done or you don't. Without paying and getting current on those things, it's gonna result in a warrant. You're gonna get arrested. And then you're gonna be on the afternoon docket in the jail. Okay? All right, so let's have you come back on. Tell you what I'm gonna do. I'm gonna kick you out a little bit further. I'm gonna do November 9th. That's gonna be the Tuesday before your expiration. Okay, so we'll do November 9th at 9 a.m. Any questions? All right, why don't you come over here and meet with Officer Matura? Do you need him for anything? Do you want me to get, do you need a reminder? You sure? Okay, all right. Oh, here you go, Mr. Wheeler. My coordinator's already done one for you. Let me just go ahead and give it to you. Sign that for me. Here you go. And then once you sign, rip that thing in two, take the back copy. Yeah, there you go. Yeah, pull that part, take the yellow copy. You got it. Thanks, sir. Yeah, I don't know why that all of a sudden came on. Mr. Stuckel.
Yes, sir.
Good morning. I'm ready to call your case with Mr. Lano if you're ready.
I'm ready.
All right, Mr. Antonio Lano, if you'll come forward, please. CR 2134.
Pinhole up there so we can see.
All right, Mr. Lano is present in the courtroom, and I show that we are set on conditions of pretrial release today. Do you have any knowledge of that, Mr. Stuckel?
Yes, I received a little bit of information from the community supervision officer, Ms. Clark, that there had been, I guess, alleged violations of the GPS by not charging properly. I can call Mr. Lano if you want to hear his testimony, but essentially, I believe that the charger has been replaced, and that since it has been replaced, that there have not been any violations.
State, have you been in contact with the pretrial release department?
No, I do have an email from Ms. Clark about the violation. However, I don't have an update about what they're planning about the battery being replaced. Send me a brief, I'll go check with them and see if that is.
Ms. Haas, we're going to step out of the courtroom and speak with the pretrial release department for just a moment.
Yes, sir.
When's the next one? The Mr. Schmidt, are you ready? Mr. Lano, if you'll just have a seat right there on the front row, either one, doesn't matter. Have a seat and I'll call your case again in just a moment. Mr. Stuckel, I'm going to take up another matter while I'm waiting on Ms. Heisel, okay?
Yes, sir.
So you ready on Mr. Schmidt? You say Hand and Richards?
Yes.
Bobby Joe Richards. CR 2134. Mr. Richards set for pretrial today. You available on the 26th, October 26th? All right, court sets Mr. Richards then for docket call on October 26th at 9 a.m. Once you sign that notice, you're free to go, Mr. Richards. Joshua Ray Hand, CR 21168.
On this again, we're set for pre-trial. I got to do the discovery on Mr. And
Any objection from state?
no.
Did you say no objection to what?
No objection to setting the call or any other.
It was pretrial or in the alternative.
I heard something about discovery, I couldn't quite hear, we have no objection.
All right, court will set Mr. Hand for pretrial on October 26th at 9 a.m. Once you sign, Mr. Hand, you're free to go. Ryan Lee Hare, is Mr. Hare here? Ryan Hare? You may.
Texted me and said that he filed a waiver of agreement on Mr. Hare on 9/21. And Mr. Hare contacted him after Mr. Hare's bondsman contacted him. So Mr. Schmidt was under the impression that neither he nor Mr. Hare needed to appear today. He said 9/21, it's 10/31.
All right, Mr. Hare, it will be set for pretrial on October 26th at 9 a.m. Ms. Heisel, are we ready to call Mr. Lano back?
Yes.
You have more information? All right, Mr. Lano, so step back up, sir. All right, we are back on the record, CR 2134, State versus Antonio Lano regarding the conditions of pretrial release. Ms. Heisel, any update for the court?
Yes, Your Honor. It does appear that he got a new charging instrument, and since that point, it has not gone completely dead, which was a previous issue. However, the probation department is still receiving notifications that it's getting below, I guess, at a certain charging percentage. It sends them a notification that it's running on low battery. They have instructed Mr. Lano to make sure that he doesn't get below that point, but there have been no violations in terms of location. There have been no instances in which it went completely dead for a period of time. So at this point, the state would not ask to hold his bond insufficient based on it. However, we would ask for the court to admonish him. You know, apparently his job causes the unit to drain faster. Miss Clark has discussed with him ways to prevent that from happening. So it's more of a maintenance issue. Judge will believe it is a violation issue.
All right, thank you, Ms. Heisel. Did you hear that, Mr. Stuckel?
I did.
Okay, good. All right, so Mr. Lano, I want you to be, I want us to be clear. I want you to understand that if your GPS unit gets below a certain charge amount and it goes dead, then that's going to be considered. I'm just going to assume that you're allowing that to happen for reasons to get around the GPS device. That's what I think when it occurs, okay? So if I see multiple portions of time where you're no longer being tracked, it makes my mind wonder, why is this happening? What is he doing, right? And so your failure to keep that maintained and charged to where I can monitor you is a violation of your conditions of pretrial release, okay? It's just like not showing up for court. You understand? So I need you to give 110% effort on making sure that that unit stays charged. It cannot go dead. If it goes dead, then I'm just going to revoke your bond in this case. I'm going to put you back in jail so that I know where you're at and I don't have to worry about monitoring you. Okay, so this is a condition that's afforded to you, all right, this being out on pretrial release, but this is a protection that the court is giving the community and placing this on you. So if you don't comply with it and you don't make sure that it's charged and reporting, it's one thing to have a device malfunction. It's another thing to not charge the device so that the device cannot function properly. You understand? We clear on that? So I understand. And so what I want it to be a forethought, not an afterthought. I don't want it to be, oh, hey, I forgot I've got this thing. I want it to be, hey, I've got this thing and I've got to make sure that it's communicating so that that judge in Canton is happy. You understand? All right. So what I'm going to do, Mr. Lano, is you were to appear this coming Monday. I'm going to reset you. I'm going to reset you until November 1st. Okay. So my coordinator is going to bring this notice of setting. That means you will not have to appear on Monday morning. Okay. So sign this, get the yellow copy. Oh, we did. Okay. Once you sign that, then I want you to come back here and check in with the probation department, pretrial release, and then you'll be free to go. Thank you, Mr. Stockwell. You're free to go, sir.
Thank you, sir.
You're welcome, sir. Come on, run this way. Mr. Wyatt, are you ready or?
I'm ready, he's on his way.
This is on Miss Jeffrey. Elaine Marie Jeffrey, CR 16416. Oh, dang, either one. All right, Miss Jeffrey, if you'll raise your right hand. Ms. Jeffrey, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Put your hand down. Make sure you speak up loudly and clearly so my court reporter here can hear you, okay? Ms. Jeffrey, you are currently on community supervision, correct? And you were placed on community supervision in January of 2018 for the offense of possession of a controlled substance in penalty group 3, less than 28 grams. On that date, the court heard the evidence, found that there was enough evidence to convict you, but the court followed the plea agreement in your case on that date, suspended or made a deferred finding on your guilt and placed you on community supervision for a period of 3 years. Court also assessed a $1,000 fine. It was during that period of 3 years that the state filed a motion to adjudicate and revoke, alleging that you violated the conditions of your community supervision. Have you had an opportunity to review that with your attorney, Mr. Nolan White? Do you feel like you've had enough time to discuss the case with him and evaluate all your options? Feel like you understand everything that you've read and signed today? And Mr. White, does your client waive the formal reading of the state's motion?
Your Honor, we waive full reading of state's motion to adjudicate. This time indicate that the board, Ms. Jefferson, enter a plea of true allegations.
All right, Ms. Jeffrey, then as to counts 1, 2, and 3, how do you plead? Are those counts true or not true? And are you pleading true to those counts because it is true that you committed the acts alleged in those counts? Has anyone threatened, forced, or pressured you to plead true to any count today? All right, court accepts the defendant's plea of true in this case. Is there any objection to State's Exhibit A, Mr. White?
No, sir.
All right, State's Exhibit A is admitted. Court takes judicial notice of Ms. Jeffrey's judicial confession. Anything further from the state?
No.
From the defense?
No, sir.
All right, Ms. Jeffrey, based on your plea of true and the evidence presented, the court finds that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement in your case. Court hereby adjudicates your guilt. That means convicts you of the offense of possession of a controlled substance in penalty grade 3, less than 28 grams, state jail felony. Court assesses your punishment pursuant to section 1244B of the Texas Penal Code at 5 days confinement in the Van Zandt County Jail. The court awards you 5 days credit towards that sentence. Court orders you to pay the balance of your financial obligations. Ms. Jeffrey, you're not going to be on community supervision anymore, and you've already got time served for your sentence, but that does not mean that you're done. What is that? What's the next step for you? What do you have to do to make sure that you stay out of jail?
Well, I think having my son as a company, that helps a lot. Make sure that I stay on my track.
You understand that you still owe money in this case? You understand that if you don't pay the county what you owe them, county is going to issue a warrant. I'm going to issue a warrant for your arrest. We're going to come pick you back up. We're going to put you back in the jail. You got to come back before me. We do this whole thing again in a sword. You understand that? All right. So I'm going to have you step forward to be fingerprinted. After that, I want you to get a copy. And then I want you to go down to the end of the hall and meet with the court compliance officer. If you're not going to pay, is she paying anything today, Mr. White?
I haven't.
All right, get a copy, go down and see the court compliance officer, into the hall on the left, Ms. Bonnie LaPrade, and speak with her about a payment plan. Come on forward right here. That's fine. Is that all you have, Mr. White?
Have Mr. Ragland.
Oh, yeah, you sure do. Mitchell Wade Ragland, CR 21-185. Mr. Ragland is set for pretrial today.
Yes, sir. Also, this eyes of this third case, explain to her I'm going to need another pre-trial. I'm just going to need to work this test, finish up some things, and ready to proceed.
Any objection from the state? You available on October 26th?
Yes.
All right, Mr. Ragland, court reset you for an additional pretrial on October 26th at 9 a.m. Once you sign and get the yellow copy, you're free to go.
All right, that's all I have.
Thank you, Mr. White.
Forming out a form for Teresa Villanueva. I think that's the last one with Mitch Adams.
Teresa Villanueva. Ms. Villanueva, your attorney, Mr. Adams, is unable to be here today. He's in trial in Tyler and Smith County. He's filed a motion for continuance in this case. Court has granted that. Court's going to reset you for arraignment on October 14th at 9 a.m. We're going to bring you this form. Once you sign it and get the yellow copy, you'll be free to go. Make sure you stay in contact with Mr. Adams. Have you made contact with him? You have? Good. Mr. Stevens or Mr. Sanders, either one of you ready to be called?
Yes, sir, I'm ready.
And Mr. Sanders, your client is online.
Okay, yeah, I'd be ready.
Are you ready on Amy Harmon? Amy Harmon, CR 21-121. Ms. Harmon is set for docket call today, Mr. Stevens.
We already are, we decided a jury waiver, we will get a plea date. So
Ms. Harmon, if you will, please raise your right hand. And do me another favor, take your sunglasses off your head. It's all right. Miss, your other hand. Ms. Harmon, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Amy Beatrice Harmon, is that correct? And Ms. Harmon, I have in my hands a document entitled Waiver of Jury Trial. Do you understand that you have an absolute right to have your case tried by a jury of your peers? Do you understand that that right cannot be taken away from you? You understand that by invoking that right, you have the right to cross-examine the state's witnesses and confront them on the evidence that the state wishes to bring against you in a trial before a jury of your peers. Do you understand that? Do you understand that if you waive your right to a jury trial, you may not be able to get that back? You do understand that? And you've spoken about this with your attorney, Mr. Stevens. Do you believe that you understand the rights that you're waiving and giving up here today? Has anyone threatened, forced, or pressured you to waive your right to a jury trial? All right, court will find that Ms. Harmon has been admonished of her right to a jury trial in this case, that she's intentionally, knowingly, and voluntarily waived that right, and that she has joined in that decision with her attorney, Mr. Bill Stevens, and also by the attorney for the state. Are you available on October 26th?
yes, sir.
All right, Ms. Harmon, we're going to come back on October 26th at 9 a.m. and you'll enter your plea at that time. Once you sign the notice of setting and get the yellow copy, you'll be free to go. Misty Rice. CR 2133. Ms. Rice is set for docket call today.
Yes, sir, we'll go ahead and see. She's received a couple of different offers, Judge, we rejected the offers.
Okay, and can I know what the offers are so I'll know what she's rejected?
2-year deferred was one of the offers. The other offer was a 1244A with a year in the county probate. And she's rejected those.
All right, so Ms. Rice, you've taken the time to discuss these with your attorney, Mr. Bill Stevens, is that right? Ma'am? Okay, and do you feel like you understand what you are rejecting here today? And do you understand that a rejection of the offers and asking the court to set you for trial will result in you getting a trial? It will not result in you changing your mind tomorrow or the day before trial. There will be no, hey, judge, I really want to take that 2-year deferred and go on probation and successfully complete it and have my case dismissed. You understand? And you understand that the range of punishment in this case is not less than 6 months or more than 2 years confinement in TDCJ. All right, Ms. Rice, the court's going to set you for jury selection on November 1st. So what you'll do is you'll report to the courthouse in the basement and you'll report there, and your case will not be reached for trial in November, but you'll get on the court's rolling trial docket and you'll remain on that docket until your case is reached for trial. Mr. Stevens is not going to be required to be here. We're not going to report here in court. You're going to report down in the basement, and my staff will be down there with additional instructions. You understand? November 1st at 8:30. Ms. Rice, there's one more issue I have. I have a note here that you're not making your payments to your pretrial release officer. I'm sorry, someone coughed. I couldn't. I'm not even sure I heard a word you said.
She has a job interview, Judge, this morning. She lost her job back in March. She hasn't worked since March. She has a job interview this morning.
All right. The pretrial release department, they monitor and they report to me. So I'm going to know if you don't make payments. Okay. All right, free to go. Court will call William Robertson, CR 21-142, CR 21-151. Show that Mr. Robertson is set for docket call, and I believe that I asked about Centacor and you indicated that your client's in the Centacor program in Waco.
That is correct, Your Honor. He's in Tyler.
Oh, he's in Tyler,
Yes, sir.
not Waco?
Oh, I'm sorry. I apologize. I have another one. He is in Waco.
Waco. All right, any objection from the state to reset for docket call?
No, Your Honor.
Do we know how long that program is?
I have no idea, Judge. This is the third time he's been in there. He was in one time for 2 weeks, another time for 3 weeks, and he went back this past month. I haven't communicated with him since he went in.
Do we have confirmation that he's actually in Centacor? Or is he just telling us he's going to Centacor every time a court date comes?
His wife told me to tell me, and we told the wife to send us documentation. I don't have documentation presented to the court today. This was Friday afternoon.
I'll tell you what I'll do then. I'm gonna issue judgment nisi, but I'm gonna take it under advisement
Okay, Judge.
until today's Tuesday. I'll do it until Thursday, close of business 5 p.m. If I don't get documentation that he's actually in Centacor, then I'm gonna find his bond insufficient, and revoke it. Tracy Smithart, CR 21-145. Thank you, sir. All right, Ms. Smithart, if you'll raise your right hand, I'm going to place you under oath. Ms. Smithart, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Your name is Tracy Lynn Smithart, is that correct? And Ms. Smithart, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? No? In this case, you're represented by your attorney, Mr. Bill Stevens. Do you feel like you've had enough time to discuss your case with him and have all your questions answered? Anything about the paperwork that you've read and signed today that you do not understand? Are you pleased with Mr. Stevens' representation of you? Mr. Stevens, do you believe your client to be competent today?
Yes, sir.
You've explained to her her legal and constitutional rights,
I have.
and you believe that she understands them?
Yes.
Ms. Smithart, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. Based on the plea agreement today, the range of punishment, the range of punishment for that state jail felony under section 1244A of the Texas Penal Code is that of a class A misdemeanor, which means punishment up to 1 year confinement in the county jail and a fine not to exceed $4,000. Do you understand that range of punishment? I see here that the plea agreement is that you plead guilty to that offense, and the state recommends that you be convicted and that you receive a sentence of 11 days confinement in the county jail, with you receiving credit for 2 days towards that sentence, a $2,000 fine, $180 restitution. The state's going to dismiss 2 cases that have not been filed, and you're going to serve the remaining 9 days on weekends. Is that your understanding of the plea agreement? And that's what you want the court to approve today? Ms. Smithart, then how do you plead to possession of a controlled substance in penalty group 2, less than 1 gram? Do you plead guilty because you are guilty and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty today? Mr. Stevens, any objection to State's Exhibit 1, stipulation of evidence?
No.
All right, State's Exhibit 1 is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
All right, Ms. Smith Hart, based on my review of the evidence, I find that there is enough evidence to convict you of this offense. Court will follow the plea agreement in your case. Court hereby convicts you under section 1244A of the offense of possession of a controlled substance in penalty group 2 less than 1 gram. Court assesses your punishment at 11 days confinement in the Van Zandt County Jail. The court awards you 2 days credit towards that sentence. Court orders you to serve the remaining 9 days as indicated in Exhibit A. Court also orders you to pay restitution of $180, court costs of $290, reimbursement fees of $715. Court also assesses a $2,000 fine. So a few things, Ms. Smith Hart. One, the money that you owe, you understand that if you do not pay that, you're going to go back to jail. You do understand that. You also understand that if you do not show up on Friday, October 1st, Friday, October 8th, and Friday, October 15th, and do your 3 days in jail on each one of those weekends, you understand that that could constitute escape and a new charge. And you understand that the jail, I send this to the jail and they put it on their calendar. And if you don't, if you show up at 8 p.m., they're not going to take you. And you need to show up with a picture ID. Okay, you have to take this order with the days, and you got to take a picture ID. And if you're 30 minutes late, they're not going to take you. They're just going to call me and let me know that you didn't show up. They're going to call the DA's office. The DA's office is probably going to ask for a new charge to be filed against you. And then we come back here and we do this all over again, but it gets worse. You understand? All right, Ms. Smith Hart, you hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted by the bailiff, and I want you to get a copy of, make sure you get a copy of this judgment and the days that you're supposed to be in jail.
I checked that first.
You're welcome. Ronald Toll, CR 21-146. Thanks, sir. Mr. Toll, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right. You are Ronald Darren Toll, is that right? And Mr. Toll, you have signed a waiver of jury trial with your attorney, Mr. Stevens, today. Did you take time to read that document? You didn't read it? You don't have your glasses? Did Mr. Stevens explain it to you? And what do you understand that you would be doing in this document today? No, as you stand right here today, you're accused of committing a crime. You understand that, right? And the resolution of that would come by way of either the state dismissing your case, or you entering a plea agreement, or you not entering a plea agreement and going to a trial before the court or before the jury. This document here says that you don't want a trial in this case, that you want to waive your right to bring in a jury, and you want to proceed in this case by doing a plea agreement. You understand that? So do you understand that in your case, you have the right to have a jury summoned and have them picked with you and your attorney in jury selection, have them sit over here, hear the evidence of the case, and decide, one, whether you're guilty or not guilty, and then two, if you want them to assess your punishment. By filling out this document and submitting it, you're telling me that you do not want a jury in this case. Is that right? And have you made this decision because this is the decision that you want to make today? Has anyone threatened, forced, or pressured you to make this decision? All right. Mr. Stevens, you've explained the waiver of jury trial to your client,
I have to.
and do you believe that he understands what waiver he's making today?
Yes, sir.
All right, court will find that Mr. Toll has been admonished of his right to a jury trial in this case, that he's intentionally, knowingly, and voluntarily waived that right, and that he's had the advice of counsel, and the state has also joined in this request. Court hereby approves the waiver of jury trial. We'll set Mr. Toll for plea agreement. Can we do that on October 26th, Mr. Stevens? All right, Mr. Toll, we're going to set you for plea before the court on October 26th at 9 a.m. Once you sign the notice of setting and get the yellow copy, you're free to go. Is Leonard Williams here? Leonard Williams?
Judge, I reached out to the office, they were going to try to get something, I've not heard back from my office.
He's the last one you have on the docket, is that right? Is he the last one you have on the docket today?
Yes.
Okay. All right.
I've got this afternoon, I'm going to be late. I sent one of my cases at 3:30, but the other just fell at 1:30. And I'm going to be late, I'll be in Kaufman, the 86th District Court for a plea and a couple of settings, then I'll head it over to the judge.
Okay.
Just want to let you know, Judge.
Okay. So you're thinking maybe about 3:30 or so you should
Yes,
be.
sir, I think
Okay.
3:30 is a wild guess, and then I'll let Patty know when I'm through.
Okay. Thank you, sir. Mr. Sanders, are you ready?
Yes.
Are you ready on Miss Wesley?
Yes.
Is she here? Amethyst Wesley, CR 21-198. Miss Wesley, were you here at 9 a.m. when I called your case? Where'd you go? Okay. All right, well, it's imperative that you be in the right place at the right time. Otherwise, it reflects poorly on you. You understand? All right, Mr. Sanders, Miss Wesley set for docket call today.
Judge, and we would ask to set it for a plea, Judge, we have a plea offer that, we're in agreement with, but, we were talking to the state about the possibility of pretrial diversion. And so we were going to be getting some items together to put that in the state for that possibility, but, subject to that, it'd be one way or another, it worked out. So we could set up a few weeks for a plea, get it taken care of. Let's stay tuned.
We can come back on either the 14th or the 26th.
But the 26th.
26th? Mr. Sanders, I think Ms. Wesley has a concern. Any issue with the 26th? Okay. All right, Ms. Wesley, we'll see you back for docket call, I'm sorry, for plea on October 26th at 9 a.m. And Ms. Wesley, once you sign that and get the yellow copy, I want you to come and report to pretrial release. I show that you haven't made any payments towards your pretrial release. Okay? Or two. Is Mr. Musgrave the only one you have left?
Yes.
I'm gonna go ahead and pull him in, make sure his technology is working.
And Judge, we might need to approach on that.
All right, Mr. Musgrave, I'm gonna call your case in just a moment, okay? Just hold what you got. Counsel, if you'll approach. All right, court calls Landon Dwayne Musgrave, cause numbers 2021-226, set for docket call. CR 28-7, possession control substance, penalty group 1 gram to 4 grams, set for open plea today. CR 21-267, assault of a family or household member with previous convictions, arraignment. Mr. Musgrave, can you see the indictment that the court has had displayed on the screen? And I'm going to ask you to unmute your device at this time.
I apologize. Yes, sir.
Okay, have you had an opportunity to read over that?
It's
I'm going to go
it's
ahead.
not letting- it's not letting me scroll to the bottom of it.
No, it won't, because I'm controlling it. So you just tell me when you just tell me when you're ready for it to go down.
Yes, sir. Okay. All right, you can scroll down, sir. Okay.
All right, Mr. Musgrave, is your name spelled correctly here in the document? Landon Dwayne Musgrave?
Yes, sir.
All right, and I'm going to admonish you that you are charged with a third-degree felony offense of assault of a family or household member with previous conviction. That carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. You understand that range of punishment?
Yes, sir, I do.
All right, and Mr. Sanders, if you'll just take a step back so Mr. Musgrave can see you there on, Mr. Sanders is present here in court. Mr. Sanders, do you waive on your client's behalf the formal reading of the indictment in this case?
Yes, sir, we would wait the recent indictment, wait the formalities of arraignment, and we enter a plea of not guilty to this charge.
The court will enter a plea of not guilty in CR 21267. Court's going to set Mr. Musgrave. Do you want me to set him for the open plea? Or do you want to set for a pretrial open plea and docket call?
We want to move all three on the docket, Judge, with the understanding that we like to be proceeding on the open plea, but that way they're tracking on the docket.
All right, so court's gonna set Mr. Musgrave. Today is September 28th. What about November 30th, Mr. Sanders? That's the Tuesday after Thanksgiving. All right, Mr. Musgrave, the court's gonna set you to appear in court in person on November 30th at 9 a.m. This will be the only notice that you get from this court. Do you understand?
Okay, and that, you said the 30th at 9 a.m.?
Yes, sir. November 30th at 9 a.m.
Yes, sir.
All right, you're free to go. Make sure that you are still reporting to your pretrial release officer and maintaining compliance with all of those conditions. You understand?
Yes, sir. I'm gonna call him here in just a minute.
All right, you're free to go.
Thank you, sir.
You're welcome. J. Byron Riddle. CR 2355, CR 2359. Mr. Riddle set for docket call today.
Last plea offer made, less than 10 years, rejected that. Jury trial, at some point, the state designated.
All right, and state, is that the best offer that's going to be made to Mr. Riddle? All right, Mr. Riddle, you understand that you are charged by indictment with Are both of these third-degree felonies?
They are, Your Honor, however, they are both enhanced to a rate.
With priors if proven? So it's HFO? All right, Mr. Riddle, do you understand that you're charged by indictment with assault of a family or household member with previous conviction, which is normally a third-degree felony, which carries a punishment range of 2 years to 10 years, but that the state has alleged certain prior convictions that, if proven true before the court, could enhance your punishment range up to a minimum of 25 years to a maximum of 99 years or life confinement in TDC? Okay, and you understand that the state has made an offer to resolve both of your cases for the recommendation of 10 years confinement in TDC. You understand that? You've spoken to your attorney, Mr. Knoll, about that, right? And you understand that by rejecting that offer today and requesting a trial is what you will get. And you understand that the Friday before jury selection, you decide, hey, this jury could give me life imprisonment and I would rather take the 10. You understand that's gone. That will not be given back to you. You understand that? Even if the state begs me, judge, give him the 10 years. I'm going to give you the trial because that's what you're asking for today. And have you taken enough time to think through it? And this is a decision that you feel good about and comfortable with and one that you're going to live with.
Your Honor, I'm giving that long to live anyway, so.
I understand, but I just want to make sure that we're clear with each other that there will be no, I want to take 10 years or 12 years or 15 years, the week before trial. Okay. All right, then, Mr. Riddle, the court will place you on the jury selection docket, and we will begin that on Monday, November 1st at 8:30 a.m. You'll report down to the basement of the courthouse, and my court staff will be down there with further instructions. Mr. Knoll's not going to be required to be there because your case is not going to be tried on that date, but you're going to check in and get your reset date, and you'll continue to do that until your case is reached for trial. Do you understand? All right. Once you sign the notice of setting for jury selection on November 1st and get the yellow copy, then you'll be free to go. And Mr. Riddle, I want you to report to Mr. Waddell for your pretrial release. I show that you owe him some money. Okay. Go meet with Mr. Waddell, and then you'll be free to go. Mr. Stevens, are you ready? Brandon Smith, CR 14193. Mr. Smith, I called your name at 9 o'clock. You weren't here.
Yes, sir. I was picking up the car about 9:01 across the street there. Yeah, pockets.
Need to be in here at 9:01. So when I'm calling your name, I know you're here and that you find that this business is important to you so that I don't revoke your bond and put you back in jail. You understand? Mr. Smith, you've requested a court-appointed attorney. Court has reviewed your information, finds today that you are indigent under the law, and has appointed the Honorable Bill Stevens to represent you. You've met with Mr. Stevens this morning. You're here for a motion to revoke your community supervision. Mr. Stevens, I'm assuming you're not ready to proceed today.
That is correct, Your Honor.
All right, so I'm going to set you on October 26th at 9 a.m. And Mr. Smith, you're still on community supervision. You still have to report any violations that you get between now and then. Your motion to revoke can be amended and they can be used against you in court. Do you understand that? Just because you're in court today doesn't mean you're off probation. Okay. Once you sign this notice of setting and get your yellow copy, you'll be free to go. You're still on probation. That's what I just told you. You need to pee in the cup. You need to report. You need to not do drugs. Everything that you're not supposed to be doing, don't do it. Everything you're supposed to be doing, do it.
think one more text. One more text for the call.
Kayla Curtis, CR 1513. Yeah, she was not here at 9 o'clock. Kayla Curtis,
Written it based on conversation I had. One asked the price got out, she got responding on 2 years. What the calculation. But I think she's gonna want an evidentiary. Fine.
as soon as we get her in custody, then we'll obligate her.
That's the rest of my.
Thank you, Mr. Knoll. Mr. Russell, I don't see you on my docket. Who are you here for?
Marcus Gardner, you're on?
Maybe I just overlooked you. Yeah, you sure are on my docket. There you are. Marcus Gardner, CR 2161, 162. All right, Mr. Gardner is set for docket call today.
That's correct, Your Honor. A little history. I'm representing a gentleman in Kaufman County that Heisel was appointed special prosecutor on. And we were supposed to have a plea last month, but it got reset by the court. We're actually set tomorrow. Ms. Heisel is going to bring me some DVDs on the case, and then I'll examine them. Either set for do the plea at the next setting or go from there. That's what- But I anticipate, once I examine that and everything, I anticipate at the next docket call. Do the plea.
Hey, Judge, that's correct. Mr. Russell, you're right. Last time we made arrangements, we bring them just to him and then that's setting up through. So I believe the discs are available in our office for pickup today. And then we'll be ready for next setting decision.
Mr. Russell, I have a note here from my pretrial release department that says that Mr. Gardner didn't report in July and August. You want to go talk to him about that real quick while I'm looking something up?
Yes, sir.
All right, so I'm just gonna note for the record, and this is no reflection on you, Mr. Russell, but this is today's the sixth setting for docket call, the sixth. Now, I know you didn't come in until July, so I'm not holding that against you, but this will be the very last setting.
Understand.
If we don't get where we need to go by the next setting, then I'm just gonna set it for trial.
Yes, sir.
All right, so tell me about the failure to report issues.
My client began checking Mr. Waddell. Last two work sessions. So that would have skipped, if we were here in July, that would have skipped him for August.
What does your pretrial release condition say? I'm sorry, I can't hear you. You're gonna have to come forward. I can't hear what you're saying.
In your honor, he's sent me a certificate of his repeat offender DWI program classes that he's done. I know that doesn't cover it's pretrial release. I mean, it may be a condition, but. But the judge is referring specifically, you should be checking in with your pretrial officer every month, not just on court days.
You see right here? You see number 2 right there? It's Mr. Waddell. See right here? Number 2, months. If Mr. Russell comes in here and asks me to reset your case for 6 months and I say, okay, you still report every month because I need to drug test you. I need to make sure that you've not absconded. I need to make sure that you're complying with your bail conditions. Okay? All right. So I want you to report to Mr. Waddell again today, and we're going to reset your case to October, which will be next month. And if he tells you to report on your court days, then that's fine. But if we ever skip a month, you have to comply with that. Understand? It's your obligation to call them and say, I need to report.
Meaning if we don't come to court, we go to the probation office.
Are you available on October 26th, Mr. Russell? I've got the 14th or the 26th. 14th is not quite a month.
Perfect.
All right, so we'll set this for the final docket call on October 26th at 9 a.m. All right, do you have a notice of setting, Mr. Russell? Once he signs that, gets the yellow copy, then report to Mr. Waddell and you're free to go.
October 26th at 9.
Yes, sir. He gets the yellow copy and the white one, you just lay down there. That'll work. You need to if you need to take a picture of that or whatever, do what you gotta do. Jacob Frericks, CR 2163. Let's let him get up here so I make sure he understands what's going on. CR 2163. Mr. Frericks is set for docket call. Mr. Ashmore has indicated that he cannot be here. He's asked a colleague who's a licensed attorney here in the state of Texas to stand in for him. Do you understand that? Okay, well then let me recall you. I'm gonna have you drug tested also. So just have a seat over there, counsel. If you'll speak with him, let him know what's going on. And then I'll have you come back up after your drug test. And so if you want to step out there and meet with them. So I want them to understand that Mr. Ashford is not going to be here and who's standing in. Is Randy Dobbins here? What about Jason Nichols?
Mr. Dobbins has stuff going right now. We have a person in the office.
Okay, I'll recall that in a second. And then Mr. Nichols is behind you. Clarence Rowan. Is Clarence Rowan here? DeAnthony Smith. There's Mr. Smith. If you're Mr. Ashmore's client and you have not spoken with these gentlemen, step out in the hallway and speak with them and then return, and then I'll call your case. save it down there in case someone else needs it. All right, so I'll see you back on October 26th at 9 a.m. Okay, and be in contact with Mr. Ashmore. All right, Mr. Pappas, we ready? All right, we are back on the record, CR 2263, State versus David Wayne McLaren. All right, Mr. McLaren. Raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right. Now, Mr. McLaren, before we go any further, I want to make sure that what you're doing here today is something that you've decided that you want to do and that you don't feel pressured or coerced that you have to do this. Okay, so I hold in my hands plea papers that tell me that you want to plead guilty to evading arrest or detention with a vehicle, and that you want to accept the state's offer, which appears to be, the recommendation is that the court not convict you today, but that the court defer a finding of guilt in your case, place you on community supervision for 3 years with a $1,500 fine, and then you'll have your conditions of community supervision plus a fine of $1,500, court costs of $290, and reimbursement fees of $90. That appears to be your plea agreement. Is that a plea agreement that you have reached with the state because that's the plea agreement you're willing to accept? And you understand that you do not have to accept this. You understand that you do have your right to a trial, just like we talked about before. But you understand that once you get that trial, you can be acquitted, you could be found guilty, you could be have a sentence of TDC anywhere between 2 years and 10 years. That sentence could be in the Texas Department of Criminal Justice. That sentence could be suspended and you could be placed on community supervision. There's a lot of things that could happen, but you understand by not doing a plea agreement today and going through that process, you don't have any control over that. Today, you have some control in decision-making. And I just want to make sure that you don't feel pressured to enter this plea agreement today. It's very important to me. Okay, so no one's threatened, forced, or pressured you to enter into this plea agreement? Okay. Your attorney in this case is Mr. Tom Pappas. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss the case with him, have all your questions answered? A lot of paperwork here. Did you read through it? You understand everything that you've read and signed? And Mr. Pappas helped you understand the legal ramifications and waivers and the things that you signed. Is that correct? He explained everything to you? Are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? Mr. McLaren, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle, and that does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice. What that means for you is if I approve the plea agreement, place you on community supervision, if you subsequently violate the plea agreement and you're brought back before the court, if the state files a motion and they prove to me that you violated, then I can assess your punishment anywhere between 2 years up to 10 years. You understand that? And understanding the range of punishment, understanding the plea agreement, you're still wanting to go forward today. Is that right? Mr. Pappas, have you explained to Mr. McLaren his legal and constitutional rights? You believe he understands them? Good, thank you. And you've explained to him the advantages and disadvantages of a deferred adjudication plea? All right, Mr. McLaren, then I'm going to ask you at this time, how do you plead to evading arrest or detention with a vehicle? Are you pleading guilty because you are guilty of that offense? Has anyone threatened, forced, or pressured you to plead guilty? All right, court accepts the defendant's plea of guilt at this time. Mr. Pappas, any objection to states one? States one, stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
Briefly, Your Honor, one of the issues, he is a driver, lives in Gainesville, we're gonna ask that his probation.
Texas or Florida? Texas, okay.
I've explained to him that it's policy for the court not to vote that unless there's something. Part of his job obligations is he drives the truck that Mark will. I don't know whether probation will have a problem with it. The state has no objection to that. I can file a written motion to get the court's permission. I'm just letting the court know that was part of how we're.
Did y'all visit with the probation department prior to the plea to discuss that?
Not part of the probation. And he can provide proof of going hard.
Okay, so that's going to be, it's going to be our condition that he not travel without permission, correct? And then Gainesville is just going to be a courtesy supervisor enforcing our conditions. Is that correct? So there's no objection from the state to.
Judge, if you want to change the condition, it doesn't make the state without permission, but for purposes, if you want to make it specific, I don't know if it's just part one. If we want to put in something like that, the state is comfortable with Ms. McLaren, obviously, still being employed, being a member of society, we'll stop that. Whatever the court feels comfortable in that regard, the state has no problem with continuing the state for purposes, really for any one purpose, any destination, particularly not hard, that's less than an hour inside. State doesn't have that.
So I don't know if the court needs it, but I can provide the address, the dates, and goes each week.
Let's do this. Let's, we may have to cross that bridge, but at this time, what I'm going to do is just leave it to the discretion of our probation department here. And then we can modify that. They can send a memo of approval to the Gainesville Community Supervision Department. If that becomes cumbersome or a problem, then they'll let me know. And then we can reach out, and if we need to have a motion with an order to allow that, then we'll make that happen because. Well, no, and I appreciate that. And like the state, I joined the state and we want Mr. McLaren to be employed. That's. Mr. McLaren, how fast were you going when you wrecked out on your motorcycle? It's a wonder that you're still alive today. You could be a puddle on the roadway. You got kids? How many? You got kids? How many? 7 kids. Are you involved in their life? 6 of them. You support them? Is that why you're working? Doesn't do a child any good to have a dead dad and a cross on the side of the road, does it? Well, you've got a golden opportunity here to to do well and put this behind you and make amends for your crime. Sure would be sad for you to live through a motorcycle accident at that speed just to be put on probation and then make another stupid decision to get violated and go to prison. Dead dads and dads in prison don't do kids any good. All right, based on the evidence, court will follow the plea agreement in this case. Court finds that there is sufficient evidence to convict Mr. McLaren of this offense. Court will defer a finding of guilt, place him on community supervision for 3 years. Court will order him to pay a $1,500 fine, $290 court cost, $90 reimbursement fees. Court orders him to do 120 hours of community service as a condition of community supervision. Mr. McLaren, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the bailiff. After that time, I want you to report to Officer Matura here and she'll give you further instructions. Yes, thank you, Mr. Pappas.
So on that issue. Is that a club?
The only ones that we have are got Jason Nichols. Where it's put the attorneys on here, all right? It's really- That's not what he says. We have it. Yeah, no, I'm saying, did they provide it to us? Service. All right, we'll go around the hall. Go on there, John, cases. All right, let's see. Brought him in. Where'd he go? All right, good morning, Mr. Todd. Can you see and hear me okay? All right, I'll need you to unmute your device there.
Yes, I can hear you, Judge.
Okay, all right, this is cause number CR 21192, State versus Keith LaTroy Thomas, and we're set for pretrial today. Do you have all the discovery in the case?
No, Your Honor. The state has, they notified me, I believe, just the last few days that they had some discovery that I need to pick up. And so I will be facilitating that. I'm not there today, of course, as court knows, but I will facilitate picking that up.
All right, so you're asking the court to set you another pretrial date?
Yes, sir, I am, Your Honor.
Are you available on October 26th?
Well, I just set I'm coming from Wichita Falls now, Judge, and I just reset that case for October 26th. So I would have the same dilemma that day.
Is that a trial or is that a hearing?
It's a pretrial. It's a pretrial also.
Okay, so I mean, I don't mind if you appear via Zoom for my pretrial.
Oh, yeah, that'd be fine, Judge.
Okay, well, let's do. What we'll do then is we'll set Mr. Thomas then at, and do you want to set it at 11 again?
Yes, sir, that would be great.
All right, so Mr. Thomas, we're going to set you at 11 a.m. on October 26th for pretrial. Mr. Todd, if he's not able to appear in person, he'll appear via Zoom like he is today. I'm going to have you sign this notice of setting. We're going to give you a copy. Once you get the yellow copy, you'll be free to go.
Thank you very much, Judge.
Yeah, you're very welcome. Have a good day.
You too, sir.
All right, bye-bye. All right, we're gonna stand in recess until Mr. Ashmore, but before we go, let's go ahead and have these names called. Bailiff, I'm gonna ask you to call the names Juan Lopez Gomez, Kayla Curtis, Leonard Marshall Williams, and Clarence Rowan. I'm gonna ask you to call their names loudly, distinctly 3 times in the courthouse. Mr. Stevens said that he'll be late. 3:30. Thanks, sir. If you can give me some bailiff certificates today before court's over, if you could. Ms. Tabraham, good for you. Court has had the following names called in the courthouse. There's no response. Juan Lopez Gomez, Kayla Curtis, Leonard Marshall Williams, Clarence Rowan. I'm also going to have Randy Dobbins' name called here after I speak with Mr. Ashmore. Just in case I don't have a COVID. Was COVID test produced to you?
Yes.
It was. Did you inspect it? You have his name, date. We've been getting pictures of COVID tests that are so zoomed in that you don't know where, who, what. All right, those names having been called in the courtroom at 9 a.m. not being present, and also His names have been called loudly distinctly 3 times in the courthouse with no response. The court issues judgment nisi and alias capias for all those named defendants. Court's going to stand in recess until Mr. Ashmore appears. All right, for the record, cause number CR 21-142, CR 21-151, State versus William Robertson. Court called that case at 9 a.m. Mr. Robertson was not present. Counsel for the defendant, Mr. Bill Stevens, announced that he was informed that his client may be in the Senecor Rehab program in Waco, Texas. However, no information has been provided to support that claim. Court is going to issue a judgment nisi and alias capias for Mr. Robertson. Court will take that under advisement until 5 p.m. on Thursday of this week, which would be September 30th. If no documentation is provided to the court will forfeit the bond and issue the warrant. Court stands in recess at this time. This is CR 21-144, State versus DeAnthony Darnell Smith. We're doing a plea?
We are.
You may. Mr. Smith, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may put your hand down. I know it's difficult. The air conditioning's on. We've got masks. It's going to be hard to hear you. Make sure you speak up loudly and clearly so my court reporter here can take down everything you say, okay? All right, you are DeAnthony Darnell Smith, is that right? And Mr. Smith, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Casey Ashmore. Do you feel like you've had enough time to discuss your case with him, have all your questions answered? Do you understand everything that you have read and signed today? And are you pleased with his representation of you? Mr. Ashmore, do you believe Mr. Smith to be competent today? And you explained to him his legal rights and both the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor.
And do you believe he understands all of those rights and the advantages and disadvantages?
I do, Your Honor. I expressing how that allows him a path, the only path to his rights as a citizen back, as well as,
May.
as well as the consequences for a violation. You know, I agree with of the successful completion of probation. Of his deferred probation.
All right, Mr. Smith, you are charged. No, go ahead. Go ahead, sign that. It's okay. Mr. Smith, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram, less than 4 grams. This carries a range of punishment of not less than 2 years or more than 10 years confinement in the state. Actually in the institutional division of TDC. If I approve this plea agreement today, what that means for you is that if you are placed on deferred community supervision, if during your term of community supervision you violate and the state files a motion to adjudicate your guilt and they bring you back to the court and they prove to me that you violated any of your conditions during your period of community supervision, the court could adjudicate your guilt. That means find you guilty of this offense, and the court could revoke your community supervision and assess your punishment anywhere between 2 years and 10 years. Do you understand that? So understanding the range of punishment, I see here that the plea agreement is that the recommendation is for a finding of guilt to be deferred and you being placed on community supervision for 6 years with a $3,500 fine and $180 restitution. You'd also have to pay court costs of $290 and reimburse Van Zandt County $805. Is that your understanding of the plea agreement? And that's what you want the court to approve today? All right, Mr. Smith, understanding the range of punishment in the plea agreement, how do you plead to that offense? And Mr. Smith, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to states 1? All right, states 1 is admitted in evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense?
No, Your Honor.
All right, based on the court's review of the evidence, I find there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement. Court defers a finding of guilt in this matter, places Mr. Smith on 6 years deferred community supervision, orders him to pay a $3,500 fine, $180 restitution, $290 court cost, $805 reimbursement fees. Mr. Smith, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm sorry, you're remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the bailiff and then report over here to Officer Matura and she'll give you additional instructions. All right, CR 2158, State versus Randy Lee Dobbins. Court has been provided with the notice that Mr. Dobbins has tested positive for COVID. Court's going to reset docket call for October 26th at 9 a.m. Jacob Frericks, CR 2163. Mr. Frericks is set for docket call today.
Judge, my client has an offer for 2 TDC. We'd like to take it today. It's me not being here, we just didn't have the time to communicate that. I know it's the lunch hour, we're asking for it, we can just have time to work through lunch, get paperwork from state, and get this done today.
State going to be able to do that?
Judge, I can ask, I was under the impression we were gonna reset for a week or 2, but I can ask if they want to come back at 30.
If it needs a reset, we'll stop it later.
We've got 21 on this afternoon's docket.
Ask if my client would sign a jury waiver. Come back and short reset.
No, just a moment. Let me think through this. Can Ms. Abney begin preparing the paperwork at 1:30? Can Ms. Abney prepare the paperwork once she gets back from lunch? And
I believe we can have it, they probably won't be done at 1:30.
no, I wouldn't expect it to be done at 1:30. All right, so what we'll do is we'll take up this case again at 1:30. But Mr. Frericks, I'm going to take you into custody at this time. Understand? For violation of conditions of pretrial release. Mr. Ashmore, are you aware that Mr. Frericks tested positive for methamphetamine and marijuana today?
I was not.
It's not really that much of an issue since he's going to be taking a 2-year time offer today, correct? That's the offer, right?
Yes, the offer.
And he's going to go in custody today and begin that sentence?
Yes, sir.
All right. So Mr. Frericks, if you'll come forward, I'm going to go ahead and take you into custody at this time, and then we'll bring you up and we'll do the plea this afternoon. Thank you. CR 2360, State versus Clarence Wade Rowan. What do you have for me on Mr. Rowan, Mr. Ashmore?
Mr. Rowland, we submitted a waiver. I think we did that this morning.
Problem with that is I don't think Mr. Rowan signed that waiver of arraignment. Am I right about that? Mr. Rowland has to sign this waiver of arraignment indicating that he understands what he's been charged with, range of punishment, that he's entered his plea of not guilty, and he has to acknowledge the next setting. So this is what I'll do for you, Mr. Ashmore. I've already had his name called. I'll take a nice eye under advisement until Thursday at 5 p.m. If you can get Mr. Rowland to electronically sign the waiver and then resubmit it, then we'll preserve his bond that way.
Okay, Judge, we'll get that done. Thank you very much.
And so what we'll do is I will just tentatively set this for pretrial on October 26th. That would be the date. I think that's the date that was on the waiver. So we'll just leave it at that and get the waiver, get him to sign it and get it submitted by Thursday at 5. And then I won't I won't forfeit the bond.
Thank you, Judge. We'll get that done. Appreciate it.
All right, does that conclude Mr. Smith pled? I think that concludes your docket. Is that right? All right, so we'll see y'all this afternoon at 1:30.
Thank you, Judge.
You're welcome, sir. All right, court will stand in recess till 1:30.